Now, this is a legit way for you to get your own hands-on experience when it comes to flying a real commercial airliner.
Welcome to Media Watch. I'm Jonathan Holmes, and that is the always hilarious Grant Denyer. The Sunrise weatherman was doing his live crosses from a Boeing 737 simulator in Brisbane. We saw him take off.
Full thrust! We'll see you guys in half an hour when we're back in the plane. A plane? What is it? It's a thing with wings and an engine, but that's not important right now.
Such a scream. And then, once he was airborne, he started chatting up the flight attendants.
How are you feeling? Are you feeling all right?
Wonderful. Yeah, I'm feeling okay.
How about now? How about now?
Oh, that's better.
Isn't he naughty? Before the simulated landing, Grant had acquired a false moustache. Even funnier.
Down. Oh, it's come down a little hard there. We got it down early.
Yeah, nicely done.
Reverse thrust?
Yes.
Everybody's safe and sound. Thank goodness, because boy, these things are hard to fly with a hangover, aren't they?
Well, all good fun, except for the date. Did Seven Sunrise realise that it was the morning of the 11th of September, the 11th anniversary of 9/11, when terrorists trained on flight simulators crashed passenger planes into the World Trade Center and the Pentagon, and thousands died? Well, no, it didn't. It told Media Watch that
it was an oversight.
Quite a big one. And now to the Twitter trolls.
This is what pushed Charlotte to the edge, to attempt to take her own life.
Please put your face into a toaster. #DieCharlotte.
There are hundreds of these tweets.
Please do the world a favour and go hang yourself. Die Charlotte.
Charlotte Dawson describing to 60 Minutes a concerted attack by the Twitter trolls, anonymous bullies who send tweets full of vile abuse, especially to celebrity users of the social media platform. After rugby league star Robbie Farah was subjected to a similar attack on Twitter about the death of his mother, Sydney's Daily Telegraph launched one of its front-page campaigns.
Stop the trolls! Today we take a stand against faceless Twitter bullies.
Page after page, day after day, the Telegraph has taken on the anonymous Twitter bullies, which is a bit odd because, as one of its regular columnists, Peter Lewis, pointed out on the day it launched the campaign,
recent polling found that Twitter is preferred by a grand total of 1% of the population. For the rest of us, it is just white noise.
Up to half of us use Facebook, very few of us spend much time on Twitter, and only celebrity users are likely to be troubled by mass troll attacks. What's even odder about the Telly's campaign is that not once in pages of outraged coverage did it give any prominence to the admirably clear advice given by the Australian Communications and Media Authority.
Trolls. 5 ways to protect yourself. Ignore the troll. Don't respond. Block the troll. Take away their power by blocking them. Report the troll. Report to site administrators. If they continue, contact the police.
Ignore, block, report. Simple and effective. But the Telly argues that reporting does no good. Twitter won't do anything, and without information from Twitter, the police can't.
Our goal is to push for Twitter to be obligated to work with authorities when these cowards break the law, bully or abuse others simply because they can, hiding behind the anonymity of their keyboard.
And which Australian law might a Twitter troll be breaking? Well, various state laws might apply, but in particular a section in the Commonwealth Criminal Code. And by the way, a carriage service used to mean the telephone, but these days it means pretty much any internet service too, including Twitter.
A person is guilty of an offence if A. the person uses a carriage service and B. the person does so in a way that reasonable persons would regard as being menacing, harassing or offensive. Penalty: imprisonment for 3 years.
3 years? That's a pretty hefty penalty for harassing or offending someone. It reminds me of a section of the Commonwealth Racial Discrimination Act, which makes it unlawful to do something in public when
A. the act is reasonably likely to offend, insult, humiliate or intimidate another person, and B. the act is done because of the race, colour or national or ethnic origin of the other person.
That's the section which News Limited columnist Andrew Bolt was found to have breached a year ago in 2 columns about fair-skinned Aboriginal people. News Limited newspapers were outraged at the finding. The Daily Telegraph editorialised then,
Bolt's columns were undoubtedly provocative and, clearly to some, offensive. But the fact a court has rendered them illegal strikes at the heart of freedom of speech, without which we have no democracy.
But when it comes to Twitter trolls, the Telegraph apparently has no problem with a law which makes being offensive not merely unlawful, but actually a criminal act. Well, the law is there, and politicians of both parties are supporting the Telegraph, all keen to haul the trolls before the courts. But, says the Federal Attorney General,
there is a problem, and the Communications Minister is also involved, which is Twitter is based in the US. It doesn't provide information.
So we went looking for examples of this non-cooperation by Twitter. The Attorney General's Department told us it didn't deal with individual cases, but
While other social networks have a good relationship with Australian authorities, to date, Twitter has not agreed to sit down and meet with representatives from either the department or the Australian Federal Police to establish a working relationship.
when we went to the AFP, they told us that harassment of individuals was a state matter. The Tasmania Police told us it was a matter for the AFP. The Victoria Police said they couldn't provide an example of Twitter refusing cooperation. In the Telly's home state, New South Wales Police told us,
for operational reasons, police do not discuss their methods of engagement with social media platforms.
Very helpful. What about Twitter itself? Its privacy policy says this.
We may preserve or disclose your information if we believe that it is reasonably necessary to comply with a law, regulation or legal request.
Recently, it's begun posting a twice-yearly transparency report. That shows that in the first 6 months of this year, Twitter received user information requests from 23 countries. They include
government requests we've received for user account information, typically in connection with criminal investigations or cases.
There were fewer than 10 requests from Australia, and in a third of them, some or all the information requested was produced. Only the Netherlands and the United States were more successful. All in all, the evidence that Twitter is being obstinately obstructive seems weak, to say the least. But 2GB's high-rating morning host Ray Hadley disagrees. He's been subjected to defamatory tweets himself, as he told fellow Talkback host Gary Hargrave on Brisbane's 4BC.
I went to the police about it. They went to Twitter about it.
But neither the police nor Hadley's lawyer got any response from Twitter. The idea of Ray Hadley, one of the most aggressive hosts on Australian Talkback radio, complaining about trolls on a medium he admits he doesn't even use, struck some of his listeners as a bit rich. One of them sent him an abusive email last week and got this robust response.
The difference between the people on Twitter, the trollsters, and me, I put my name to what I say. No one's got to go looking for me. I'm here. 6 days a week, you imbecile. Saying the sort of things I'm saying to you right now.
Hadley insists that Twitter refuses to give up the names of anonymous trolls, even to the American courts.
In fact, in the Supreme Court in New York at the moment, they're fighting against a court order to reveal details of a tweeter who's done exactly what the type of thing we're talking about today, about spreading, vile rumours about people and not being accountable, and Twitter won't release to the authorities in New York the details of the person doing it.
Last week, Communications Minister Stephen Conroy was in furious agreement with Ray Hadley.
Your fundamental point is right. If Twitter are prepared to defy their own Supreme Court, they're not prepared to cooperate with the authorities in their own country, we have a real challenge to get them to pay attention to us.
But just a minute, what is this New York case about? Is it really about
a tweeter who's done exactly what the type of thing we're talking about today, about spreading, vile rumours about people?
Well, no, it's not. Not even remotely. Both Stephen Conroy and Ray Hadley have confirmed to Media Watch that they were referring to this case.
The people of the state of New York against Malcolm Harris.
Malcolm Harris is not a Twitter troll, and nobody is alleging that he is. He hasn't been spreading vile rumours about people, and he's certainly not anonymous. He's a young man who's charged with disorderly conduct on the Brooklyn Bridge following one of the Occupy Wall Street protests in New York City last year. The New York District Attorney wants Twitter to surrender all Harris's tweets over a 3-month period. The DA is looking for evidence to strengthen the case against a political protester. Twitter is arguing that it doesn't own the tweets, Harris does, and that it shouldn't have to surrender them unless the authorities do what they'd have to do if they wanted to search his house, get a search warrant, not a mere subpoena. Twitter is supported by the American Civil Liberties Union.
We're hopeful that Twitter's appeal will overturn the criminal court's dangerous decision and reaffirm that we retain our constitutional rights to speech and privacy online as well as offline.
In other words, the New York case has nothing to do with Twitter trolls. Twitter is appealing to the Supreme Court against a contentious ruling by a criminal court judge, which it has every right to do. There are some fundamental principles at stake. And incidentally, Twitter users in Syria or Burma or Iran will be happy to know that it doesn't easily hand over their details to their governments on request. In an editorial last Thursday, the Daily Telegraph responded to some of its critics. It contrasted Twitter's approach to Facebook's.
Facebook, to its considerable credit, is impressively active on this front. You will not bully, intimidate or harass any user. Facebook's terms of service explain you will not post content that is hate speech, threatening or pornographic.
But as the Telegraph reported 2 days later, Twitter has recently amended its own terms of service.
Twitter's rules of engagement now clearly state technical abuse and user abuse is not tolerated on twitter.com and will result in permanent suspension.
Well, Twitter may need to become more proactive about the trolls, but the fact is, most of the cases of serious harm from cyberbullying in Australia still involve young people being mocked or harassed on Facebook, chat rooms and message services, often not by anonymous trolls, but by people they know. One of the most acute comments I've heard on the subject this week was this one by Tori Maguire of News Limited's The Punch.
In spite of everyone's collective wisdom that the best thing to do is to not feed the trolls, currently there's a bloody feeding frenzy going on. Yes. And they're being given every single thing that they want, which is attention. They're on the front page of every newspaper, and if I was a crazy little troll, I'd be so excited about that. And the way to manage these people is to just get rid of them.
Ignore, block, report. Or forget about Twitter altogether. After all, unlike the schoolyard, you don't have to be there. There's more detail, especially about that New York case, on our website, and you can leave your comments, polite ones please, while you're there. Or you can post them on Twitter. Until next week, good night.